My name is Michael Frumkin, and I'm the organizer of this University of Miami Law School seminar on the constitutional crisis. Our topic today is formal correctives, including constitutional reform. And we're privileged to have with us Sanford Levinson as our speaker. Sanford Levinson is genuinely a giant of modern American legal scholarship. He holds a W. St. John Garwood and W. St. John Garwood Jr. Centennial Chair in Law at the University of Texas, Austin, and is also a professor in the Department of Government at the University of Texas. To say he is prolific is a vast understatement. He has written more than 450 articles and book reviews in professional and popular journals, and has also written or co-authored count them, seven books, including Constitutional Faith and Our Undemocratic Constitution, Where the Constitution Goes Wrong and How We the People Can Correct It. And most recently with Cynthia Levinson, Fault Lines in the Constitution, which also comes, believe it or not, in a graphic novel edition. Meanwhile, he co-authored a leading constitutional law casebook and many other edited or co-edited collections. Honestly, I lost count how many, but it includes Torture, a collection, and the Oxford Handbook of the United States Constitution. Amidst all of this, he's a regular contributor to the Balkanization blog and a valued and near daily contributor to the Constitutional Law Scholars mailing list. He's been a visiting faculty member at Boston University, Georgetown, NYU, and Yale Law School in the US, and has taught abroad in programs of law in London, Paris, Jerusalem, Auckland, and Melbourne. He's also been a regular visitor at the Harvard Law School. Professor Levinson's writing is clear, often provocative, and always attuned to both political reality, political theory, and legal developments. He is no stranger to written debate, but he is civil and thoughtful, even kind to his interlocutors. If I had academic heroes, Sanford Levinson would be on the shortest of shortlists. I'm so delighted to welcome him to speak to us today. I'm going to turn off my microphone and let him take over.
You, the students, have read it or at least skimmed it. I'm not going to take the next hour simply repeating what was in that. What I do want to draw on are two things that have been published very, very recently. One in the Wisconsin Law Review with a title that I'm very proud of, Comments by a Cantankerous Crank on Constitutional Theory, the Supreme Court, and the Legal Academy. The other, I literally just got this past week from the Florida Law Review, up the road. This is the double bind of the United States Constitution. So what I want to do in the next 55 minutes or so is concentrate on these two pieces, but certainly link them with what I ask you to read. What I ask you to read certainly underscores the extent to which I really and truly do support a new constitutional convention. What started out now 40 years ago as kind of, a thought experiment, an academic conceit. Why not play with this idea? Clearly, there wasn't going to be a new constitutional convention, but let's speculate on what it might do, whether if you could wave a magic wand, it could be useful, et cetera. So, I wrote some stuff along those lines. But over the years, it has become definitely more serious that my present frame of mind is to view the Constitution itself as central to our crisis. So it is not merely that there are people who are disregarding the Constitution or who are pushing the envelope to the extent that they're tearing it into many different pieces. We could talk about that, and I will be around in the second hour, certainly welcoming any questions you might have or any comments you might have along those lines. But it is often said that the scandal is not what illegalities are committed, what crimes are committed, but instead what is perfectly legal. So, in fact, for example, this semester I'm co-teaching a seminar at the Harvard Law School with my friend Larry Lessig on what a new constitutional convention might actually look like. Larry is extremely well known in constitutional law circles for a very virtuous and justified critique and political fight he's been conducting now for at least 20 years on the role of money in politics, the corruptions posed by the way that we finance campaigns. The problem is that almost all of this is perfectly legal. Every now and then, somebody violates the law. George Steinbrenner, former owner of the New York Yankees, I think actually was, violated the election law rather than merely took advantage of its possibilities. But generally speaking, rich people can figure out a way to take advantage of the legal possibilities and thoroughly corrupt the American political process. So that is one problem. And one of the reasons that Larry supports a new constitutional convention, and I have to say, when the two of us are in a classroom, we come close to constituting a majority of mainstream constitutional law professors who actually support a new constitutional convention. It's almost literally the case that I can name every mainstream law professor who actually thinks a new constitutional convention would be a good idea. But the reason Larry wants a new constitutional convention is because he wants to overturn Citizens United. Now, the paradox is that we don't need a constitutional convention. We don't even need a constitutional amendment. All we would need is capture and control of the Supreme Court, and the Supreme Court deciding, as it should, that Citizens United, even if correct in the very particular case, which is easy, I think, to argue, that it was grotesquely overbroad in its holding and should be overruled. But that's not going to happen for a variety of reasons. Conservatives have firm control. And if you are waiting around for a liberal Supreme Court, it's just not going to happen. So therefore, you need a constitutional amendment. And the only way to get a constitutional amendment is through a constitutional convention. You can't get it as a practical matter through what all of us know is the ordinary process of constitutional amendment. That is 2/3 of each House of Congress and 3/4 of the states, because the people in Congress, whether they are senators or representatives, all owe their prominence to being able to play the campaign finance game very, very well. And so, as a practical matter, there is no possibility of serious reform of campaign finance coming through a congressionally proposed constitutional amendment in our lifetime. I'll also mention another feature of our system that is behind my own call for a constitutional convention. I believe that electing members of the House of Representatives exclusively through single member districts is a terrible way of constituting the House of Representatives. If you look around the world, very, very few other political systems adopt our mode of election. Single member districts first past the post, meaning except in those very few cases that have adopted ranked choice voting, all you need to do is come in first, which is very different from getting majority. But in any event, what really bothers me is the exclusive reliance on single-member districts. It is single-member districts that generates the terrible, terrible problem, corrupting problem of what I call gerrymandering. My wife calls it gerrymandering. I think most people use Jerry. I go with Gary because that was the way apparently Elbridge Gerry pronounced his name. But if we didn't have single member districting, if we had some form, say, of multi-member districts with proportional representation, you would have a far different House of Representatives. You would have a House of Representatives, among other things, that might even meet the test allegedly handed down in 1964 in Reynolds versus Sims, where Chief Justice Warren said the key feature of the American democratic system is not only that your vote should count, obviously, but the majority should win and there is fair and effective representation. Now, for a variety of reasons, majorities don't necessarily win. That follows from so-called first past the post, where the only thing you need to do is come in first and no majority is required. But it also means that even without conscious gerrymandering, it is the case, because of the way we distribute ourselves, that Democratic minorities in West Texas, for example, get no representation, and Republican minorities in New York City or in the coastal part of California, by and large, get no representation. Whereas if we had proportional representation, not only would there be, I think, more fair and effective representation, but also, quite frankly, we could break ourselves free of the two-party duopoly. American exceptionalism is in part defined by the fact that a country of 340 million people, stretching from Maine to Hawaii in the mid-Pacific to Key West in the South, operates under a two-party system. Almost all other countries that we call democratic have multi-parties. Many of these countries have formal systems of proportional representation. Now, this is not constitutionally required. The reason we have single-member districts is because of an 1842 law passed by Congress and then reaffirmed in effect by Congress, I think in 1969. Congress could change that tomorrow if they wished. But for the same reason that it is impossible to imagine members of the current House of Representatives saying, well, let's just blow things up and let's make it much less likely that I will be reelected and that we will stick with the politics as usual of a Democratic Party and Republican Party rather than a 3 or 4 party representative system in the House. That's not going to happen. And the only way it can happen at the national level is through a constitutional convention. If we nationally were like California, or perhaps like Florida, I don't know as much about the Florida system as I should, but I do know that we, the people of Florida, voted several years ago to restore the right to vote to convicted felons. And then the Republican legislature did whatever they could to sabotage that. But I do know that the state of Florida, like most states in the union, have some procedure for direct democracy. If we lived in California, then, and if you agreed, for example, that we should get rid of single-member districts and replace them with another way of electing representatives, then we could stand at street corners and try to get people to sign a petition. And if we got enough signatures, we could have a statewide election to reform the Constitution. That cannot happen at the national level. And that was intended. James Madison was proud of the fact. In fact, he capitalized it just in case we missed the point. In Federalist 63, he was proud of the fact that there is no iota of direct democracy in the United States Constitution. Direct democracy for Madison was ancient Greece, was Athens. And he said, Athens didn't work. After all, they executed Socrates. And that's just enough to discredit the idea of genuine popular rule. So the genius of the national Constitution, according to James Madison, was that even though the Constitution is ordained in the name of the people, we the people have no role whatsoever in actually making any decisions. It's all going to be done through representatives. And that then is why campaign finance becomes so important, because the representatives in the modern system need lots of money, and this gives a disproportionate role to people with lots of money. And we elect them through the first past the post single member district system, which also gives a very distorted notion of representation. One of the reasons I have so relatively little faith in the United States Supreme Court is precisely that it's now 61 years ago that they said, you know, when we evaluate the American election system, we should ask, does it allow majorities to rule? And does it provide fair and effective representation? That's the last time, almost literally, they said anything about this. In the 61 years since then, the United States Supreme Court has said nothing really useful about how one should analyze and assess the American electoral system. The notion of one person, one vote does not, in fact, describe the American political system, because a lot of people are represented who can't vote. And we could argue, and after the break, if I'd welcome questions if you wish, on whether people who can't vote should necessarily be represented, whether they're children, undocumented aliens, felons, or whatever. But if you thought that, well, the point of these decisions is that each person's vote should be equal to every other person's vote, we don't operate in that system. And the Supreme Court has never bothered to explain why it is that we have a system of representation that, in fact, doesn't really accord with one person, one vote. It does accord with other theories of representative democracy, but my complaint is that the Supreme Court has never bothered to set out a systematic theory of representative democracy. And I really do feel a certain sort of pathos when we teach these cases, because by and large, the more time you spend with most of the Supreme Court cases, the less truly educated you are in how to think about representative democracy. What you are educated in is how to be a practicing lawyer, manipulating the words and phrases that the Supreme Court uses. And that's important if you're a practicing lawyer. I've done it myself. But it's very, very different from actually preparing or wrestling with the deep theoretical issues involved around theories of representative democracy, a debate or democracy, a debate that in fact has a 2,500-year history and has never been completely resolved. So let me turn to the first of the two recent pieces, the comments by Cantankerous Crank on constitutional theory, the Supreme Court, and the Legal Academy. So what has made me cantankerous and something of a crank is that I really am upset with the way that constitutional law is defined as a subject within the American Legal Academy, because it is defined more or less as what the Supreme Court says. Charles Evans Hughes is famous for having said, "We're governed by the Constitution, but the Constitution is what the Supreme Court says it is." There is a truth to that. If we are talking about election law, it is an unfortunate necessity that you read the Supreme Court cases, because if you're a practicing lawyer, you have to know the way the Supreme Court thinks and talks. I often compare the Supreme Court to the childhood game, or at least the game in my childhood, of Simon Says, where Simon says, take 2 steps forward, 1 step backward, or hop on 1 foot, or, rub your head in your stomach at the same time, and then you do what Simon says. Well, that is what the Supreme Court does. It tells us how to talk like lawyers. But my complaints are twofold. One of them I've already indicated, that what Simon says about representative democracy is not, in fact, very helpful if you're genuinely interested in theorizing about representative democracy and trying to figure out what that can possibly mean in the 21st century. Now, to be fair to the Supreme Court, they haven't been educated to think like political theorists. And they're also members of a 9-person committee that has to try to come up with decisions that get 5 votes. So there's the old adage that a camel is a horse designed by a committee. And there's a lot of truth to that. And so one has to realize that majority opinions, and especially unanimous opinions, may often look like camels because somebody had to make compromises in order to get the 5th vote, or in some cases like Brown versus Board of Education, the 9th vote. And you can read the cases and reread them, and you're still going to be left scratching your head at the end of the case because you're just confused. And one of the things that I always tell my students is that if they're confused, that often means, not always, but it often means that they really understand what they've read, that they should not assume that because they're confused, they're dumb. They shouldn't be in law school because if they were smarter, if you were smarter, then you would read these decisions and say, oh yeah, I really do see how all of this makes sense and hangs together. No, sometimes a decision will, but very often the correct response is to say, this doesn't make all that much sense. I'm really confused about what they're trying to say. And that is often true. And so to the extent that we focus entirely on what the Supreme Court says about issues, rather than look at what non-judges, non-lawyers have to say about these issues, you might very well be worse off than you were when you actually started reading the opinions, because you'll simply be confused and not having taken the time to read stuff that would really be more challenging and more cogent. So that's one of the things that has made me a cantankerous crank with regard to the legal academy. But the other thing that I'm a crank about is that we live in a country with 51 constitutions, not only one constitution. Every state has its own constitution. And every state's constitution is interestingly different from the national constitution. I don't know as much as I should about Florida, but I do know that Florida does not have a unitary executive. In fact, something like 45 or the 46 American states have thoroughly rejected the unitary executive. In Texas, I will simply tell you, we elect everybody except the Secretary of State, an insignificant office that the governor of Texas does get to appoint. But every other major state official is elected. And this includes, among other things, the attorney general. So you think right now of some of the debates or arguments we're having about the Trump Justice Department, or for that matter, the Biden Justice Department or whatever. And if you think about American states, it doesn't make any sense to talk about the governor's Justice Department, because the attorney general is often from a different political party, or even if from the same political party, is often ambitiously running to be governor him or herself, and cannot be counted on to be a loyal ally of the governor, even if they're the same party. So one of the things that I'm upset about with regard to the teaching of American constitutional law is that we don't teach American constitutional law. We teach the law of a single constitution that is, to be sure, the most important of the 51 constitutions. But generally speaking, students are not made truly aware that there are other ways of doing things than the US national constitution. There are courses in comparative constitutional law that I think are important, but usually they're comparing the US Constitution with foreign constitutions, German Constitution, French Constitution, Spanish Constitution, etc., which is important and valuable. But I also think we ought to be comparing the national constitution with your own state constitution, and then with other state constitutions. I've already mentioned, for example, the importance of the fact that many, many states make room for direct democracy, and that we would have very different conversations about what might be done if the national constitution had direct democracy, or if the national constitution had the provision that 14 state constitutions have, where the electorate, every given span of years, 10 years or 20 years, gets to vote on whether or not to have a new state constitutional convention. New Hampshire, for example, has had 17 state constitutional conventions, because the New Hampshire Constitution, I think, started off with every 7 years. It's now every 10 years, but they were really very frequent. There have been over 235 state constitutional conventions. And so what I have discovered, and perhaps you are like my students at Harvard, almost none of whom like the idea of a new constitutional convention, because of course they would say it's never happened. And that's true if you're thinking at the national level. It happened only in 1787, and since then it's a blank slate, but it's happened 235 times at the state level. But To an amazing degree, nobody knows about that. So that's part of what's made me a crank. But another part of it is that I now believe very, very strongly that what might be the most important parts of the United States Constitution, and if most is a bit of an exaggeration, I'll settle for at least as important parts of the national constitution are never taught at all. Why is that? I distinguish in a book that I wrote between the Constitution of Conversation and the Constitution of Settlement. By that, I mean the Constitution of Conversation is what is litigated, what goes before the judiciary, especially before the United States Supreme Court. So the judges themselves are conversing about this, they're arguing about it, they're insulting one another about the answers they come up with. But if you're talking about, let us say, affirmative action, abortion, hate speech, guns, lots of other things, the sort of things that regularly come up in your constitutional law case, then you identify that with the Constitution. Most people, if you ask them, well, what do you think of when you think of the US Constitution? What do you like about the US Constitution? What is it that you think important about the US Constitution? The answer is going to be rights. That the wonderful thing about the Constitution is that it protects your rights, like freedom of speech, freedom of religion, etc. I think these are important. I do not disdain the protection of rights, but I do believe that it is at least as important to talk about how we structure American politics in ways that makes it more likely or less likely that we as a collective people will actually respond to the challenges that many people will define as the issues that keep them up at night. And it doesn't matter where you are on the political spectrum, because among these issues are paying for healthcare, climate change, getting some control of immigration, getting some control of entitlement spending, getting some control of an ever-mounting US debt, providing affordable housing. And there are others as well. So I really do not mean to make this a crass political argument. I think if you look at the polling data, where you discover that at least 2/3 of the American public in most polls believe that the country is headed in the wrong direction, you discover that an overwhelming majority of people do not approve of Congress, do not trust Congress. You discover this is by and large true of the president, whoever is in power. This has now become true for the first time in American history of the Supreme Court. People are very frustrated about what government produces. Professor Frumke mentioned that my first book in what's turned out to be something of a trilogy was Our Undemocratic Constitution, published in 2005, 2006. I think I demonstrated to my satisfaction and to most people's satisfaction that the Constitution really isn't very democratic. What I also discovered is that most people don't care. It is like sausage or a pudding, that what you care about is how it tastes, what the product is. And if you're relatively satisfied with what government is doing, then you don't really care if some academic political theorist says, this is not really a very democratic system at all. So what if the product is reasonably successful? However, One of the differences between even 2005, which Professor Frumkin can testify was no bed of roses. It's not that we were all dancing in the streets with sheer pleasure at how American government was working. But that was an era when George W. Bush and Teddy Kennedy were capable of negotiating with one another and passing important legislation. We were not so polarized as the country you're living in. So my point is that if I were asked to ask you or your parents, your friends, what issues keep you up at night, I'm fairly confident it would be one or more of the list that I gave a few minutes ago, and that you would be very frustrated when you look at Congress because you would not believe that Congress is capable of meeting the challenges. We just suffered through a month-long government shutdown. The fact is, some people noticed it. If you were on SNAP, you certainly noticed it the last week. If you were part of the privileged class that depended on air travel, then you noticed it last week. But to a remarkable degree, a lot of people didn't care that much that the national parks were closed or you couldn't get into some sort of national museums. And what you do know is that Congress passes very little legislation. And what legislation it does pass, by and large, cuts the taxes for rich people. It does not respond adequately to the list of problems that I've suggested. Now, why is that? It is because we have a Byzantine system going back to 1787 that was actually designed to make it very, very difficult for government to function. My wife and I, the third book in this trilogy, so to speak, the second one was called Framed, America's 51 Constitutions and the Crisis of Governance. The third book, my wife and I wrote for teenagers, notionally. In fact, earlier today, we were Zooming with some students in Texas to talk about the 21 fault lines in the Constitution. And most of them are structural. Most of them have nothing to do with what the Supreme Court does. Rather, they are the features of our system that make it difficult, sometimes to the point of impossibility, to achieve any kind of effective governance. So we begin the book, for example, with bicameralism. And my wife is a prize-winning children's author. She has a real talent for telling stories and for conveying them effectively. So we begin with the question, why until last year, the book has just come out in the third edition, why until last year, 2023, was there no federal anti-lynching law? The first proposal for a federal anti-lynching law was in 1921. A Republican member of Congress from St. Louis, Missouri. And I will say, to prove the fact that I'm not merely a political partisan, one of the aims of the book for me is to rehabilitate Warren G. Harding, who is usually regarded as at the bottom of the list of American presidents. Warren Harding actually supported a federal anti-lynching law. I will also say he commuted the indefensible sentence of Eugene Debs of 10 years in prison for opposing World War I. But in any event, he supported an anti-lynching law. It did not pass for another 100 years. And the reason, by and large, is the United States Senate. And the fact the United States Senate was controlled until I was in graduate school, which is now 60 years ago, but in the 1960s, it was effectively controlled by white supremacists from the South who could simply prevent a federal anti-lynching law from even coming up for a vote, let alone passing. This is the filibuster. But it actually gets worse. because one of the chapters in our book on fault lines in the Constitution is the presidential veto. And we point out that we really have a tricameral system, not merely a bicameral system, because it isn't enough to run the impressive hurdles of getting legislation through both the House of Representatives and a Senate that gives way, way too much power to small states. Even if you get through those two hurdles, a president can veto a bill. And so we point out that Bill Clinton and George W. Bush both vetoed bills dealing with fetal research and reproductive rights. We're confident that nobody in the country supported both of those vetoes. But the more interesting question, in a sense, is whether we should oppose both of those vetoes. Should it be enough for legislation to get through both houses to become law, or at the very least, should it be easier to overcome presidential vetoes? And here's where comparative state constitutional law becomes interesting, because there are all sorts of possibilities in the American states with regard to overcoming gubernatorial vetoes, ranging from 2/3 to, in North Carolina, simply the state legislature voting by a majority saying, yeah, we've read your message, we respectfully disagree, we're repassing it. What are you going to do about it? The answer is nothing. I suspect that all of you spent time in your constitutional law course talking about the countermajoritarian difficulty. That's an important topic. What has made me cantankerous is that there are so many other counter-majoritarian features in the American political system that we never talk about at all, because they're not subject to litigation. The presidential veto is not subject to litigation. Bicameralism is not subject to litigation. The fact that Vermont and Texas, Wyoming and California have an equal number of senators is not subject to litigation. What part of two do you not understand is enough to answer the question of why is that constitutional? But it has tremendous consequences with regard to the possibility not only of passing a federal anti-lynching law, but of passing laws regarding healthcare, climate change, getting control of the border, entitlement spending, getting control of the national debt, or whatever might be the issues you most care about. And that's not taught at most law schools because it's not litigated. And the only thing we teach are the parts of the Constitution that's litigated. That's all of which are interesting and important. I don't mean to say they're not, but it's also interesting and important to talk about how the Constitution structures our political system in a way that will make it less likely that the government will be able to function effectively. Okay, I think I've got about 10 minutes to go. Is that right? So let me switch to the other article, the double bind of the United States Constitution. What do I mean by that? Double bind was a concept created, I think about 70 years ago, 67 years ago, by psychologists to refer to a psychological phenomenon where you felt absolutely conflicting emotions toward people or institutions, but particularly people who were very important to you. Primarily your parents. That's where the concept was originally conceived. You loved your parents, but you also hated your parents. And one of the reasons for that conflicting set of emotions is that you would get conflicting demands or commands from your parents. It isn't that everything they were telling you to do was consistent. Instead, they would give you inconsistent sorts of commands so that whatever you did, you'd be getting it wrong. And that generates psychological tension. Now, this was originally conceived to help explain schizophrenia, and I believe that it's now agreed that it doesn't. But it remains a useful concept, or at least I was trying to use it as a useful concept, because I think that we are in a double bind regarding the US Constitution. That is, part of us, and I will say part of me, admires or loves the US Constitution. You know, if we're talking about First Amendment, freedom of speech, stuff like that, what's not to like, even if we might argue about certain features of First Amendment doctrine? I love the preamble to the Constitution. It's a great preamble. It should make all of us proud in terms of setting out the goals for the Constitution. But I will also say that over the last 40 years, I've not only become more critical of the Constitution, but there are some features of the Constitution that I've really grown to hate and really do believe are dangers to your future. I'm old enough, frankly, that I'm not that fearful of what will happen to me in the number of years remaining to me. What keeps me up at night would be our children, but our children are now middle-aged, or our grandchildren, and that's another matter. And that is why government needs to act in certain areas, and we might disagree on what the most important areas are, or we might disagree on what the specific legislation ought to be. But where it is hard to disagree is whether Congress will in fact do anything. And generally the answer is no. And generally that answer is because the Constitution is structured in such a way as to make congressional action next to impossible. That is something I think needs much, much more discussion than it gets. And it also helps to explain why I want a new Constitutional Convention. But it operates against the background of the double bind. James Madison in Federalist 49 said that it was very, very important that all of us venerate the Constitution. He was writing Federalist 49 as a critique of his very good friend Thomas Jefferson, who said, really, we should have a new Constitution every 19 years. The world belongs to the living, and it really doesn't make any sense to be governed by the dead hand of the past. No, Madison said that takes us down the road to instability. We were incredibly lucky. All the stars were aligned in 1787 that we had this fabulous group of people in Washington who were able to design a constitution. It's unlikely to happen again. And what we ought to do is instill in the people a veneration of the Constitution so that when they look at the Constitution, their heart beats faster and they view it basically as a sacred document, as a document they love. They celebrate it every September on Constitution Day. The other side of the coin is to be critical, to engage in what Alexander Hamilton in Federalist 1 called reflection and choice about how to be governed. And my criticism is that we ourselves, we, the contemporary people, do not engage in reflection and choice about the Constitution. I'm always very, very careful to say I do not engage in founder bashing. They did the best job they could, given the political and social realities of 1787. That included, among other things, designing the Senate the way it was designed, and making terrible, terrible compromises with slavery. That was the price of getting a constitution. We could argue, and we ought to argue, was it worth it? But at the very least, you should recognize James Madison, for example, described the equal voting power in the Senate as an evil. He said it's a lesser evil, but it is an evil. It was a lesser evil of having no constitution at all. This was true also, say, with Gouverneur Morris from Pennsylvania, who recognized the awfulness of enslavement. He gave a great speech in Philadelphia on the awfulness of the international slave trade. But he ended up voting for it because he recognized that the only way to get a constitution was to make that very, very terrible bargain. But the point is, they were serious politicians, they were serious thinkers, engaged in reflection on choice. What did the circumstances require? Their debates were fully serious. Today, we spend way, way too much of our time venerating the Constitution and almost no time engaged in serious reflection and choice about how we ought to be governed in the 21st century. And that's a question very, very different from, well, what do you want the Supreme Court to say about fill in the blank? Because as important as those issues are, they don't speak to the structural problems of the unlitigated Constitution and all of the ways that the unlitigated Constitution make it less and less likely that there will be either reflection or choice about the issues that keep us up at night, or at least that keep me up at night. So this is why I really do spend so much of my time now, and why I was thrilled to be invited by Professor Frumkin to participate in this seminar, and thrilled to be teaching the seminar with Larry Lessig. And I did a reading course at the Harvard Law School called Reforming the U.S. Constitution, and will be teaching a similar seminar at the University of Texas in the spring, because I really do think that that is the most important single topic before us as people who are devoting our lives to thinking about the Constitution, its merits and its defects. I think probably I can put a period there. Michael, if there are a couple of minutes left and you want me to address something for a couple of minutes before the break, I'll be glad to. But I think I've pretty much said my piece.
So that was absolutely terrific. Thank you so much for that. We'll take our usual 10-second break and then get back to business.